All right, students, welcome back. Um, I hope you're enjoying your consolidation week up on campus and you're consolidating yourselves. This is your videos for your property law lecture. So I've already uploaded the law first set of lectures, the second set of lectures, and then we have the contract law lectures, which contract law was because of the problems of the internet on Friday. We didn't cover that class, but I've uploaded the notes and the lecture note as well, and also the slides as well. All right, so now when we look at the topic of property law, I've covered that in class, but we're just going to quickly make all these videos to supplement your sort of learning. So you have the understanding of property law as well as other law topics in the economic law space there. All right, so when we looked at the first sort of notes, we said that some grand themes that we gave you, or I gave you in the lectures. The first one is possession is 9 parts of the law. That means that possession is not a complete exhaustive sort of definition of the what it means in terms of owning something. You actually don't own you don't own anything. You own rights in things. Various people can own different aspects of property at the same time. And then the extent of your property interest is measured by how many sticks you have in a bundle of sticks that is property. Yeah. So who has the most complete sort of range of interest there? All right, the dividing line between chattel and land is fixtures, and you are safe when you get registered. Example, if you get a land title and you get a registered title in the registry. All right, it's a rush to the register, so whoever comes first to register the interest basically as a upper end. And if your registration works against you, you will be compensated. All right. Some basic definitions that we can look at. All right. The Land Act 996, it talks about the definition of property. So it states that all land in the country other than customary property of the state, subject to any estate's rights, titles, or interest in force under any law. And then all estates' right, title, interest under the customary right in land at any time held by a person held under the state. So land is not customary land, belongs to the state. So the above statement means that all land as property is vested in the state apart from customary land. The state then decides what to do with property. It has residential, commercial, or special purpose leases back to businesses and individuals. In PNG, the Secretary of the Companies Act defines property as property of any kind, whether tangible or intangible, real or personal, corporal or incorporeal, and includes rights, interests, and claims in every kind in relation to property, however they arise. All right, so when you break that down, basically property is tangible and intangible property. Tangible property is physical property that can be touched or felt. It includes real property, which is land and things attached to it, and personal property, which is movable property like cars, furniture, jewelry, etc. All right, intangible property is non-physical property that cannot be perceived by the senses. It includes assets like money in your accounts, also includes stocks, bonds, patents, or copyright. All right, real or personal property. So real property encompasses interest in land and fixtures or structures upon the land. Personal property encompasses tangible or corporal things, chattels or good. So real property encompasses interest in land and fixtures that are not that are or structures upon the land. And personal property are tangible property, which is like chattels or goods. So a fixture is different from a chattel. All right, corporal or incorporeal property. Corporal property is the right of ownership in material things, such as land and ownership. That right you have, it's called corporal property. And incorporeal property are other property rights in rem. So incorporeal property itself is two kinds. One, it's a jura in reporia, we say, property rights over immaterial things. So things like patents and copyrights, it's an immaterial thing. So when you talk about incorporeal property, we call them property rights in rem. Or the first one is jura in reporia. Repropria, this is Latin for property rights in patents and copyrights, and then trademarks, and then we call them jura in re aliena, or encumbrances, whether over material or immaterial things. Example, mortgages are. So when you get a mortgage of a bank, sign a loan agreement with the bank, get a mortgage of 400,000, you purchase a property, that mortgage right there that the bank have until and unless you repay the loan, and then you they give you the title, the bank's interest, the mortgage instrument will be registered on the title. So that's the bank's sort of jura in re aliena. That means that it's an encumbrance that is registered on the title. All right, I hope that's clear. All right, let's say property as a legal relationship. So in terms of property, there are three parties here. The state, the person the state has concluded is the owner of a specified form of property, and any person whom the state has concluded does not own a specified form of property. So there are three persons here. One, the state, as the you saw above in the law up there, state owns all lands allowed in customary land. And then the state can grant the title of residence or lease, subsection law, to a certain person. And then when the state grants the title to a certain person, it does not grant anything else to any other person. All right, property is separate from the thing itself that we looked about. The concept of property is said to be referred to a bundle of rights that make sense with respect to that object. So property separate from the thing itself. Our property interest, ownership, is the highest form of property, possession, and then security interest, example, bank. So a number of people can have property object at the same time. Example, A owns a car, so A is the owner, lends it to B, possession. If C steals from B, C has possession. B and C are subject to A's interest. So A is the owner as the highest form of property. All right, private and public communal property. Private property is predominant in Western culture. Public property, even if property owned by the state, it is owned in the same way as private owners. All right, communal property. This was made famous by the very famous case of Eddie Mabo versus the state. It challenged the legal doctrine called the doctrine of terra nullius. Basically, when the colonizers and Europeans came to Australia, they said that the land was ownerless, vacant, and because of the people, Aboriginal people living on the land were savages, as a result, cannot sort of effect the power of ownership. Eddie Mabo challenged that case in the High Court of Australia, and the High Court of Australia basically struck down or nullified the doctrine of terra nullius, and they said that the land was owned by the indigenous owners or Aboriginals in accordance with their custom. All right, in the next slide, we look at categories of properties. Thank you.